Hi, everyone. Taylor and I will get started in 3 minutes. Hi, everyone. Thanks so much for joining us. We really appreciate you spending your lunch hour on Monday with us. And we're really excited to talk to you all, whether you're a current business owner or a aspiring business owner, to talk to you all about business planning and even some about estate planning as well. And get to know you all and open up this space for questions. And I do want to make a point to say there are not differences between a man owning a business and a woman owning a business. What we thought was really important was there are a whole lot more female owned businesses now, and it's growing each year. And we wanted to open a space for you all to learn and ask as many questions as you want. So with that being said, please feel free to send questions in the chat to us throughout, and we'll stop and answer some questions, or we may save some for the end, especially if maybe we're getting to a point that you asked about and you're thinking ahead. We may wait to answer it at that time, but we'll definitely answer any and all questions that you all have. That being said, Taylor and I will introduce ourselves. My name is Natalie Gilbert, and I am a senior attorney here at Evans and Davis. I live in Oklahoma City. I do a lot of traveling to our other offices, which Taylor will talk a little bit more about. But I went to undergrad at the University of Oklahoma and got my degree in psychology. And then I stayed another 3 years to go to law school at OU as well. And I love being involved in the community. So this also lists a few things that I'm involved in here and am really proud of. So happy to be here.
Hey everybody, my name is Taylor Kincannon. I'm an attorney at Evans and Davis. I've been here for about 5 years. I went to Southwestern Oklahoma State, SWOSU, and then University of Tulsa for law school. I, like Natalie, work in some of our different offices outside of Oklahoma, from Edmond to Denver to Tucson. Some of the things that I'm involved with are listed here: Victims Impact Panel and the Regional Food Bank of Oklahoma. I'm super excited to talk to everybody today, kind of go through an overview, a primer of business planning and starting and owning and maintaining your businesses. So at Evans and Davis, our firm, we've got about 40 team members, attorneys and staff in offices all the way from Atlanta and North Carolina and Nashville out to California, Washington, Oregon. We focus on estate planning and business planning. What does that mean? Under the business planning umbrella, what the bulk of our conversation will be about today is creating your businesses, LLCs, corporations, things like that, making sure you have all of the legal documents that you need to have in place, maintaining your business, buy-sell agreements, which is an agreement between partners, that we'll talk about in depth on this webinar, all the way to dissolving businesses, mergers and acquisitions, drafting, reviewing contracts, leases, things like that. And then under the estate planning umbrella, we've got wills, trusts, trust administration, probate. And so that's the personal side of what happens to not only my ownership in my business, but to all of my other assets when I pass or when I'm incapacitated, and what happens when the business gets caught up in those life events, which is something that we're going to discuss today as well.
We're going to start with the business planning piece because I think that's why a lot of you all are here, and it actually wraps into estate planning. So we'll end with talking more about that. But whether you have already started a business or you are thinking about it, these apply to you. So when you're starting a business, you need to decide what entity makes the most sense for me. And we're going to talk about what those options are and the pros and cons of each. And how do I form that entity? What documents do I need? This is a big overview of the different types of entities. I won't read the whole form to you, I promise, but we will talk about each of these in more detail, but you can see that talks about the various taxation for each entity and the formation documents that are required. And those are what will be filed with the Secretary of State or the Corporation Commission, depending on what state you're in. We're going to first start by talking about a sole proprietorship and what that is. So a sole proprietorship it's just me. So if I decide today I want to go into rental properties, so I buy a rental property and my tenant is going to sign a contract with Natalie Gilbert. There are no requirements to the sole proprietorship, but there's also no protections that come with the sole proprietorship. So I'm very exposed to liability. If my tenant invites their friends over and someone steps off the back porch and breaks their ankle, they're suing me and coming after my house and my bank accounts. Whereas if they have formed an entity, and we'll talk a lot more about this, that's going to put a bubble and a shield of protection around me. With just a sole proprietorship and not having formed an entity, I'm leaving myself super exposed. So we we at Evans and Davis do not promote the sole proprietorship. We want an entity form so that you have that protection around you.
Definitely. So what types of entity are there? Dependent on the state, there is an option that is a partnership. So we're going to talk a lot today about creating liability bubbles, protecting your personal assets from your business liabilities. A sole proprietorship and a partnership are both default business entities for when you start a business. If you haven't formed an LLC, a corporation, anything like that, if you're going it alone, let's say that we started, 3 years ago, say we started a business that sells fidget spinners, and we're, taking advantage of this huge market for these kids that are using fidget spinners, and it's just me alone selling these things, and I haven't filed anything formal with the state. Well, I'm a sole proprietorship. And as Natalie said, if one of my fidget spinners has a piece that breaks off and a kid swallows it, those parents are probably going to sue me personally. And since I don't have any formal entity set up and I'm a sole proprietorship, all of my personal assets, if I own a rental house, if I own, investments, if I own a bunch of Bitcoin, things like that, all of that is subject to a lawsuit. But let's say instead of a sole proprietorship, me and Natalie say, hey, we have this great idea. We should start producing fidget spinners with the OU logo on it or something like that, with the Colorado Buffaloes logo on it. And so me and Natalie agree verbally or in a contract to start producing fidget spinners and selling those. Now we're a partnership because we didn't file anything formal. If you're in Texas or some other states, you can file to be a formal partnership. And there are different variations of partners. You can be a limited liability partner. You can be a general partner, things like that. But generally, if Natalie and I don't have anything formal put into place, we're just going to be general partners, and we're going to be liable for whatever debts, whatever lawsuits, things like that the business is liable for. We want to avoid that. Like I said, we're going to try to create pockets of liability protection. And the two main entities that do that are corporations and LLCs. Let's start with corporations because we're going to use LLCs for most of our examples today. Corporations, you file articles of incorporation or a certificate of incorporation, depending on what state you're in. The Secretary of State says, okay, we're going to let Natalie and Taylor's Fidget Spinners, Inc. proceed as a business. Well, now we need to have a board of directors. Me and Natalie are shareholders. We can bring other people on. But there are drawbacks with starting a corporation. The drawbacks are there's a stringent record keeping requirement. We have to meet every year. We have to have documented those minutes and what we've talked about. It gets complicated because we have to have bylaws. We have to have kind of all of those documents put into place. And if we don't, then a court could void any of that personal liability protection, which we have a whole slide on. To add to that, stringent record keeping requirement, those complicated annual minutes, things like that, taxation is going to be a little bit different. So just a regular C corporation, the entity is going to pay taxes. So all of the money that we make from our fidget spinners or whatever we're producing, shoes, pre-made meal kits, whatever. All of the taxes are going to be paid by the corporation for anything that we sell. And then when Natalie and I take distributions from our company, because the goal of us starting a company is to get paid and to make money and to support our families, we're going to pay taxes on that income as well. So there's just, a lot of complicated measures and extra taxes that need to be paid. If you're a C corporation, there's an option to file as an S corporation. And we're not going to get too far into that because we know enough to be dangerous, but we're not CPAs. But the S corporation election allows you to only pay those personal taxes. But if you have questions on that, you can shoot us an email, chat, and we can hook you up with a great CPA. Natalie's going to talk a little bit more about LLCs, which we've been referring to a lot, but we haven't really defined.
Right. And there's a time and a place for a corporation, and it may be that your business grows and a corporation makes a lot of sense. But the most common starting business entity is the limited liability company or the LLC. The LLC gives you a whole lot of flexibility for our fidget spinner company. So we can maybe Taylor started it first. And so first he's the sole member, which the member is kind of the owner of the business interest. So he's the sole member and he's taxed as a disregarded entity. Well, now he comes to me and says, I have this great idea. Let's put OU on fidget spinners. It's going to be a killer business idea. And I'm like, I'm all in. So now he adds me into his LLC, and now it is a multi-member LLC, and now we can be taxed as a partnership. And maybe there are benefits of that, and we're working with our CPA to do that. Well, now 2 years later, we've grown, and maybe it makes more sense to be taxed as an S Corp, and there's more benefits of that. We can be constantly changing. We can add more members, or if we want someone to be involved in the day-to-day activity, but maybe not be a business, we can add managers to our LLC. And that's all taken care of in the operating agreement. And we'll talk about that in a little bit, but that's the required kind of governing document for an LLC. There is not a requirement for Taylor and I to file meeting minutes stating that we met every single year and what we did at that meeting and what we decided, like at a corporation. It's a whole lot more simple. There are less requirements that we need to meet each year to make sure that we're in good standing and that our liability protection bubble is still in place. There's a couple other different types of LLC that I'll stop for a second and talk about too. One is, let's say I want to go hang my own shingle because I'm tired of working with Taylor and I want to go work on my own. So I may want a professional limited liability company, and that's for what it sounds, certain professional careers. It's for doctors, dentists, vets, attorneys. There are a little bit more requirements, but it brings with it prestige. There's some different protections and some different requirements that different states require that you need to place yourself in that PLLC world. There's also a series LLC. So I'm going to go back to my rental property business. So maybe I start with one property, but now I've bought 3 more, and I want to convert my LLC to a series LLC, because a series LLC is now going to create a series for each of my houses. So series A owns my first house and series B owns my second, and so on. And now it's created a specific bubble of protection around each property that I own. So it's a really cool way to provide specific focus protection to each property. So if someone steps off my back porch or the back porch of property 1, they can only sue series A and not series B, C, D, E. So that's another kind of cool, different type of LLC that could make sense for you. So when we're forming an entity, one of the first things that we need to decide is, what are we going to call our entity? If I'm hanging my own shingle, maybe I want it Gilbert Law Practice LLC. If it's, I would look and see if that name was available. If it is, it's free game. If no one else has that name, or if Taylor and I want to call our fidget spinner company Fidget Spinners R Us, then we're going to look and see if that name is taken or not. If it doesn't look like anything matches that, then we can go ahead and file for it, and the Secretary of State or the Corporation Commission is going to tell us that it's available. There's filing fees that come with forming an entity, and every state is different. Also, maybe by my rental property company, I also want to buy a property at Lake Texoma on the Texas side. Now I have exposed myself to the laws of Texas. So now I need to file myself as a foreign entity in that state because I'm also doing business there. I also need to decide on my registered agent. The registered agent is a person or an entity that will accept service on your behalf. So if someone sues you, or if someone is providing you notice of something that includes your business, they're going to receive that notice on your behalf. So this could be you, but it could also be your attorney. It's something that we do all the time. They're also in charge of filing an annual renewal of your business. It's another way that you're protecting your liability around your company, because if you don't file your annual renewal, then the state doesn't really see you as a viable business. Now you're not in good standing, you're inactive, or if you let it go too long, you're expired. And that's the last thing that you want, because this seems like a fairly easy thing that each year you pay your fee to renew and to remain active, but it's a really easy way. If you forget it, or the Secretary of State does not always send you the timely notice, or maybe you put in one address that you used to live in 2 years ago and now you don't live there anymore, so you're not receiving notice of that renewal. So it's out of sight, out of mind. It's something we see all the time when clients come in. They say, yeah, I own a business and it's this, and been in business for 10 years, but they haven't filed their annual certificate in 3. So they've been doing business not in good standing. And so we can bring that up to date. It's not the end of the world, but it is something that can cause exposure to liability.
Definitely. So kind of going with what Natalie and I have been discussing, less stringent record keeping requirements, why we prefer LLCs when we're just starting out. One crucial piece of that LLC is an operating agreement. This is sort of the handbook for how the business is going to operate. And so while we've both said there are less stringent record keeping requirements, there still are some requirements. The operating agreement is kind of, every state is going to have an LLC Act, and it's going to say, what votes are required for certain topics. It's going to say who's subject to what liability. In the operating agreement, we can set forth the things that we have to set forth, and then we can deviate from the Limited Liability Company Act of your state with some of those decision-making powers and powers of the managers or members of the entity in our own operating agreement. So the operating agreement is going to say who the managers are. That is people without ownership who can act on behalf of the business. It's going to say who the members are. Members can also be managers, but the members are who owns units in the company. So corporations have shareholders, LLCs have members. So who are the members who have an interest in the ownership of the company? It's going to say, a certain threshold that, if Natalie and I start a business, but then we say, one of our coworkers, Ryan, is the manager, and Ryan can go enter into contracts on our behalf. He can use a company credit card up to $500, things like that. Then Ryan has the power, according to our operating agreement, to bind our company, our LLC, to go make purchases and things like that. So that's the difference between members and managers. We can also say what threshold voting requirements there are going to be. If it's just Natalie and I, it's probably going to be that we have to be unanimous if we're 50-50 partners, because then that's going to say we need to agree on everything. Alternatively, if there's 5 of us and we all own 20%, then we could say that we need a majority or a supermajority for whatever we're agreeing on. The operating agreement is going to set forth what percentage everybody owns. It's going to set forth what their capital contribution was, which is important when it's taxed as a partnership. And then there are going to be optional provisions there, such as buy-sell provisions, which we'll discuss a little bit later. But that's what happens if I die. What happens to my interests in the company? Do they go to Natalie, and is my family bought out? Does my family continue to gather rents if it's the rental property company? Things like that. Maybe we want to include a right of first refusal that says if I want out, then I have to offer my share to Natalie first. Operating agreements can be as simple as complex as you want to make them, but there are specific items that need to be included. And sometimes, although LegalZoom may seem like a more affordable or the cheaper option, those provisions aren't always included. I would say almost 100% of the time when we're reviewing an operating agreement from LegalZoom, what are the risks there? Because an attorney in your state may not have drafted it. Risks being, a company has been operating for 35 years, but the operating agreement says that after 5 years, the company is supposed to be dissolved. Well, there are problems there on if the LLC's limited liability extends past that 5 years at all. If something happens, maybe we have a default partnership now. Maybe the people operating that business are personally liable for the debts or the lawsuits that business incurs. So just be careful where and when you're getting those documents drafted, whether it's online or by CPAs, attorneys, things like that. Why is it important to maintain our corporate documents and to make sure that we have the proper business structures and we're following all the rules that we need to? For this, not the sole purpose, but the main purpose, as we've talked about, creating liability pockets. If I am using my personal bank account, but I have filed a single member LLC that I'm the only member of, or if I forget to file my annual renewals, or if I don't have an operating agreement that says I have limited liability from the debts and the lawsuits that the business is involved in, well, now I'm going to incur some personal liability because I'm not actually treating my business as a separate entity. So now Taylor's just manufacturing and selling those fidget spinners or take-home meal kits, whatever. Taylor's doing that personally. And when Taylor's not maintaining a line between what I'm doing personally and what the business is doing, a court can look at that and say, you're not operating a separate bank account, you don't have an operating agreement, you haven't been filing your annual renewals, so your LLC is lapsed with the state. And at that point, the court can say, we're going to set that veil aside, that veil of limited liability, and we're going to pierce it and come after you personally. So there's kind of a list here of all of the things that, can contribute to a court making that decision. So we want to make sure that we always file our annual renewal. We have an operating agreement in place that sets forth the fact that I'm separate from my LLC, whether I'm a single owner or not. We want to make sure that we have corporate minutes or bylaws dependent on what type of entity we are, and that we're not commingling and maintaining a separate bank account.
So we had a question that specifically asked, if I have an LLC and I'm the sole owner, do I still need an operating agreement? Because it may seem silly because you're meeting with yourself, right? And you're voting with yourself, but it's still a requirement by states that you need to have it in place to just show that you are an official business. It does not have to be complicated. It can be simple, but it's important to have. And we also just got another question, is the operating agreement have to be filed? The answer to that is no, it does not have to be filed. But when it comes time to sell your business, or in the event there is a lawsuit, that's going to be one of the first things I ask for. Minutes are required. That's another question that we got. These are all good questions, so I'm going to stop and answer them. How often do you have to have minutes is another question. You have to have that. The minutes are not required except for a corporation. And in a corporation, you have to have annual minutes. And if there are special decisions that are made in the year that's outside, maybe we're adding a member, maybe we're a shareholder, a director, then there needs to be special minutes that show that that decision has been made. But at least annually is the answer to, do I have to have minutes? But that's for a corporation. LLCs do not require annual minutes to be created each year. It's good to have clear books and records, like Taylor said, and to have your separate bank account that says, this is where the money has gone. Not that I'm going to Target and I'm buying my fall decorations for my house out of my business account. That's not what that's for. It needs to be for business expenses, and it needs to be really clear that those personal and business expenses are separate.
Another good question, just because Natalie's touched on series LLCs a couple slides ago. What other business examples do we use that for aside from rental properties? Really, investment properties and rental properties is the sole reason that you would want to use a series LLC. If I have a Spigot Finners LLC, and I have my home delivery meal kit LLC, those are two completely different types of liability, and I want to keep those separated in two different pockets or two different LLCs. The series LLC, I can use that when I have multiple investment properties, and I can deed a property to each series underneath one LLC. That way I'm separating it that way, but it was pretty much created under state statutes solely for those investment LLC owners. Another thing just quickly that I wanted to point out, what goes into the annual minutes, it's everything from what Natalie was saying, that we elected a board of directors, that we had a change in the officers of the company, all the way to ratifying the acts of the board of directors from the past year, to adopting a budget, to agreeing to dissolve the company. So any decisions that the board or the shareholders are making on behalf of the corporation have to go down in those annual minutes or special minutes. If you're going to make a decision, maybe your annual meeting is January, and in September you're going to elect to dissolve, you need special minutes for that. Or you're going to pay a new dividend, you need special minutes for that. If you're an LLC, the same is not true. The LLC, you have the decision-making powers that the operating agreement says you do, and you can just go do that without those stringent record-keeping requirements.
So we already talked about making sure that you have an official business entity set up, that you have your governing documents in place, operating agreement for an LLC or bylaws for a corporation. It's also really important to have, if you have employees, there should be an employee agreement in place. You may think nothing is going to go wrong, but it very well could. And it's better to be prepared and have provisions in your employee agreements, whether that is a W-2 employee or a 1099 employee. It's good to have those agreements in place, as well as your employee manuals. A succession plan for your business is really important. And Taylor touched on a buy-sell agreement earlier. The buy-sell agreement is going to be the document that says what happens when I die in our fidget spinner company, what happens if I get cancer and I can't work for a year, what happens if I decide that I want out, what happens if I get out and then I go make my own fidget spinner company down the street, where we're going to incorporate all of that into the buy-sell agreement. Sometimes buy-sell provisions are included within an operating agreement. A lot of times it's nice to have them in two separate agreements, because you may be wanting to make changes in your buy-sell agreement that really don't impact your operating agreement. Also, it tends to be that buy-sell provisions in an operating agreement may just cover what happens at death. There's a whole lot of other things that are included and should be accounted for in the buy-sell agreement. And a handshake agreement is not a good buy-sell agreement. We've talked about it. Our families are good with it. We all understand what's going to happen, because without something in writing, things with businesses and relationships, they just can get messy. So it's better to have a fallback, even if maybe you agree to something that isn't in the buy-sell agreement, but everyone's good with it and you sign it, and that your 50%, my 50% goes to Taylor and it's super smooth. But we have that buy-sell agreement in place that says, if we couldn't agree, this is what's supposed to happen. This is the price of my 50% ownership, or this is how we find that price through a formula or through an appraisal. And this is, I want my family to receive life insurance in the amount of X that I think that we've agreed on, that is the value of our business. Or if I decide to retire, then what does that look like? What does that buyout look like if I retire? Because it may look a little bit different if I'm retiring versus if I die. Same with disability. I think I'm taking some of Taylor's slides, sorry. But those are some of the things that are incorporated in that buy-sell agreement. And whether you're in business with a friend or an acquaintance or a family member, it is so often not prepared for of what's going to happen to your business interests. And 30% of business, or only 30% of the time, do businesses survive into the second generation of the family, because there's not planning in place. It's usually assumed that it's going to go where you want it to, but it may not. If you want the business to go to your children, nieces, nephews, your siblings, or to the other business owner, that is something that should be talked about and put in writing in your buy-sell agreement or in your estate plan, which we'll talk a little bit more about here in a little bit.
So just kind of to rehash, again, those buy-sell agreement triggering events. Why do I need a buy-sell agreement that says what happens with my business interest in me and Natalie's business when I die, or when I'm disabled for 12 months or things like that. I need that because it makes it easier for the business to keep operating. So what are those triggering events? Death, disability, involuntary transfers, like maybe a spouse has acquired my interest in the business through divorce or bankruptcy, things like that. Retirement, maybe I just want to step away, but 10 years ago, we prescribed what the process is for me retiring in a buy-sell agreement, which just makes that agreement much easier, or makes that period much easier and less stressful on the partners. Maybe voluntary termination. I just want to step back. I'm not retiring, but I'm just done with the business. Involuntary termination, if I get fired for embezzling from the company, and Natalie's like, wait a second, you're out of here. You violated a term of our buy-sell agreement. And it sets forth what happens there. Or if I want to sell to a third party, but my buy-sell agreement says I have to make an offer to Natalie first. Those are some of the reasons that I want that buy-sell agreement to be in place. A buy-sell agreement can state, like Natalie said, it can say, if our business is worth $100,000, me and Natalie can both go get life insurance for $50,000 each. And then when I die, my life insurance is going to my family for $50,000. And then my $50,000 business interest is going to Natalie. So there's offsetting there that can be funded through life insurance, or a promissory note that says over 5 years, Natalie's going to pay my family $10,000 a year plus interest. They can be broken out over monthly payments to make it easier for Natalie to both continue to run the business and to buy out my family. So there's just a lot that goes into buy-sell agreements, whether it's a part of your operating agreement or a separate agreement that help the businesses succeed when one or two or multiple partners die, become disabled, things like that. So tax consequences of selling your business. As we said at the beginning, neither of us are CPAs. Just some things we wanted to touch on. If Natalie and I start a business and then we pass, or if I start a business by myself and I pass, and when I started my business, my capital contribution was $100. My business is worth $100. It doesn't own property. But then when I die, my business is worth $2 million. My beneficiaries are going to get a step up in the tax basis of my business to $2 million. So if they want to sell it 10 months after, they're going to pay the difference from when I died to when they sell it, not from when I started it. And so there are some key considerations to make when you're thinking about either selling your business or maintaining your business till you pass. Talk about that with your team, your attorney, your CPA, your life insurance professionals, and make sure that you're making the best decision possible, not only for the ease of transferring that business on to the next generation or to your partners, but also for you tax-wise. What else do I need in addition to an operating agreement, a formal entity filed with the state, things like that? A business license. If you're a plumber or if you're an electrician, make sure that your license is either in the name of the company or that you can do business on behalf of the company using your license. Sometimes we'll file, Oklahoma Electricians LLC for somebody who's been operating as a sole proprietor for 40 years. Well, now we're taking care of that limited liability, but we also want to make sure that that electrician's license allows that entity to continue to operate under that license, or that if to be a member, you need to have X license. Like Natalie was saying, if we started a law firm tomorrow, our operating agreement needs to state that you have to be an attorney. And so we need to have our, our bar association number for wherever we're operating that. Titling business assets, it's not enough just to start an LLC and say, pay rent to my LLC. We need to make sure all of our properties are owned by that LLC or that series LLC. We need to make sure that each series owns that property. This is just a good list of, hey, what do I need to make sure I'm doing when I've started and start operating my business?
I wanted to jump in on that piece. And if Taylor and I start our own law firm and we go by the building and that we're going to set up shop in, but then we have our, our practice. We don't want to own our building and do our law practice out of the same LLC. It's a whole lot better to separate that liability. And, Taylor Natalie Properties LLC owns our building, and then Taylor Natalie Law Practice is what is running our practice. And then Taylor Natalie Law Practice can pay rent to our properties LLC. That's a tax saver, but it's also going to separate those two liabilities, which is what we want. And it kind of separates our exposure there. We got a question that says, do you recommend putting your personal home in an LLC? This isn't far off topic at all. No, we wouldn't recommend putting your house into your LLC. We would recommend putting it in your trust. So thank you for that excellent transition, Caroline. But we don't want your house in your LLC because it's separate and apart from your business. We would put, if you have an estate plan, we want your trust to own your business interests, and that still keeps that liability protection separate. We want your house can file a homestead exemption and get some liability protection around it that's statutory. And so you don't need it to be in the LLC. It's a really, really good question though. And so exactly where we're headed is how does my personal estate plan affect my business? And so like I just said, it's going to if you have a trust, that's what should own your business interest, whether it's your LLC interest or your stock in your corporation. Your trust will own it, and that's going to allow it to avoid probate. Also, if I own my real estate investment business solely, what's going to happen? How do I don't have a buy-sell agreement with myself, and Taylor's not my business partner for us to have a buy-sell agreement together. So my personal estate plan is what's going to govern what happens to my business if I die tomorrow, because I can say, I want my sister to take over for me, or if I have 4 children, but only 2 of them are involved, well, then I want that business to be divided between my 2 children. And then maybe I want to kind of equal out in other ways to my 2 other children that aren't involved in the business. Or maybe I want them to receive rental income, but not ownership in the business. So there's a lot of things that we can account for if I'm owning my business, just me and myself. What is my estate plan? What does it mean to have a personal plan as opposed to my business succession plan? So my estate plan says what happens to all of my personal assets. So my residence, my personal bank accounts that aren't in the business name, what happens to those after I die? And that includes, that's a will or a trust. And we'll talk a little bit more about the differences in those. But why do I need my own personal plan? just some of the same reasons that we need a business plan. It's going to avoid conflict. It's going to tell my family and my friends exactly what I want to happen, and tell the state exactly what I want to happen when I die, and no one is questioning that. And the state isn't telling my family what should happen to my assets. I get to decide that. It's private to create a trust. Nothing is, just like a operating agreement doesn't have to be filed, a trust doesn't have to be filed anywhere. No one can see that unless I give them permission to see it. We also want to avoid probate. So I had a client that she and her husband had been married 40 years, and we had started to do their estate plan, and we were a couple months in, and they were trying to make some decisions. He was the sole owner of their business, and he died in the middle of our planning, and a plan is not in place until you sign it. And all of that business, she couldn't sell the business. She couldn't take over as sole owner of the business until the court was completed the probate process. So it's stuck and frozen in probate. If my trust owns my business interest, then it doesn't have to go through the probate process at all. A court doesn't have to decide or approve of what's going to happen to the business because my trust owns my interests. Your estate plan is also going to say if you have kids or if you will have kids in the future, it's also going to say who's the guardian of your kids and who can make decisions for them. Also, who can oversee the money. If you're not here to provide funds for them, who's in charge of doing that and making sure that they're taken care of and all of their needs are provided for financially. So there's 3 different options. If you don't have a will or a trust, well, you have an estate plan under the statutes of the state that you live in. That's what's going to say happens to where your business interests go. That's what says where your house goes. A will is where you can say, this is who I want to be the guardian of my children, and this is who I want to be the executor of my estate. So following the instructions of my will, and here's where I want my assets to go. But still, with a will, it still has to go through probate process, which is what Taylor's about to talk about. A trust is going to avoid the probate process altogether. And I will stop taking Taylor's slides and I'll just let him explain that.
No, you're killing it. You're killing it. So just briefly, the probate process and what we're going to keep referring to and what Natalie was discussing. The probate process is just the state where you live. That's their process of getting your assets from, a dead person's estate, from being owned by a decedent to the beneficiaries or who should receive that according to what state law says. So whether you have a will or whether you have no plan at all, we're going to go through this same process. In our illustration, it starts with filing a will. If you don't have a will, we're just going to skip that step. But generally, it takes longer and is more costly than doing your planning up front to go through the probate process. If you're in California, you're going to pay a fee just for passing away that says if my estate is worth X, I'm going to pay Y to the state just for dying. So generally, we want to avoid that, not only because it's costly, it's time consuming, but also maybe you don't want your assets to be distributed the way that state law does, or you don't want your assets and who's getting them to be public information. Whether you have a will or not, that's going to be filed in the county that you pass away in where you lived. And so generally probate is long, costly, we want to avoid it. And there are ways to avoid it by putting a plan in place that is called a revocable trust. What is a trust? So revocable or living, those just mean that you can change it at any time during your lifetime. So if you think of the trust as a bucket, you're putting all of your titled assets that you own right now into your bucket. You're the only one carrying that bucket. You're the only one that can take assets out and put assets into your bucket while you're living. When you pass, that bucket becomes irrevocable. So there a lid goes on the bucket. You've named in your trust who's carrying that bucket and who's dumping those assets out of the bucket for what beneficiaries, when, where, and how. When it comes to using that bucket to distribute your assets, you have to fund your bucket. So funding is just putting your stuff in your bucket, like the slide says. We want to make sure that all of your assets are either titled in the name of your trust, so they're in your bucket, or titled in the name of your LLC or your corporation, because we've assigned your ownership in that business to the corporation. So, broad scope, a trust is just an instrument that you move your assets into, whether that is, life insurance beneficiary being the trust, so everything's funneled through that trust, whether we're retitling your home in the name of the trust, we're assigning your business interest to that trust, to that bucket, and it avoids probate because when you pass, nothing is owned in your personal name anymore. So we don't have to go to the probate court to move the title from the decedent, from the deceased person, to their beneficiaries. So that's kind of generally how a trust works. And that is, from New York to California, we can utilize trusts to avoid probate, to use a private distribution of your assets from that trust. And we can also dictate how your beneficiaries are going to receive those assets. So that might be anything from, in my trust, if my little brothers are my beneficiaries, but they're both college aged, and I don't want them to get half of my estate immediately because I don't know how long that would last, because like I said, they're college aged, then I can step out those distributions in my trust to make sure that my assets are there for their health, education, maintenance, and support until age 30. And then at that point, they can just take everything out of the trust if they want to. The revocable trust can also provide some protections to my beneficiaries if they're going through a divorce, if they're going through, if they have a medical creditor issue, if I have a beneficiary with a disability or a special need, then I can protect them from the public benefits that they're receiving. So all of these things go into your trust, and all of your specific situation needs to be considered when you're doing your trust-based planning, because you can provide so many more protections to your beneficiaries than passing with no estate plan or passing with just a will in place.
And your estate plan includes more than just your will and your trust. So that's going to actually include it's going to incorporate your buy-sell agreement. It's going to include your powers of attorney, both financial and medical, and your advance directive, the funding, the filling of the bucket, all the documents that includes. And that's something that our firm takes a lot of pride in. We do all of that for our clients. We don't just send you on your way and say, you fill the bucket, we fill the bucket for you. And there are a lot of attorneys that don't do that. And a not filled bucket is a useless bucket, because we are avoiding probate by those assets being titled in your trust. So it's super important. We also do a couple of other documents, like a funeral service memorandum and a personal property memorandum.
We got a question. It's a good question. Why do so many people say they have an irrevocable trust while they're still living? So not to steal from Natalie's slide, but that first thing there is, revocable means you can change it at any time. Irrevocable means you can't change it. Revocable means you have control over the assets that it owns. Irrevocable generally means that you don't. I have a revocable trust right now. When I pass, it becomes irrevocable. So a lid goes on that bucket, and no one can change the assets that are in that bucket or the terms of how that bucket's being distributed. Sometimes people might just be confused and say they have an irrevocable trust, but really mean they have a revocable trust because they're not estate planning attorneys. They don't deal with that every single day. Or sometimes people will have an irrevocable trust. With an irrevocable trust, you can use that for asset protection. You can use it for estate tax, liability, for reducing that estate tax liability, death taxes, things like that. But with the irrevocable trust, you're generally losing control or relinquishing some control of that asset. And so you'll just have to talk with Natalie or I or your estate planning attorney to determine what type of trust is best for you and your particular situation. So hopefully that helps answer that question. But a lot of times people use them interchangeably, even though they don't mean to.
And it's very likely that you may know people with irrevocable trusts because if you have an irrevocable trust, you most likely have a revocable trust, kind of your base planning is what we call it. And then you have additional irrevocable trusts. They're more complex and are not for everyone. But there are some people that we definitely do that type of planning for. It just depends on your situation. So our last slide kind of is some questions that you can ask yourself, whether you are a new business owner or a seasoned business owner. If you create, if let's say you have a partnership now and you think, gosh, I really should have done an LLC, that's okay. You can change it. It is not too late to change things like that. We just want to rope in your CPA and making that change. These are just some good reminders and things for you to process. It's a really, really good idea to have a good team around you when you own your own business, that you have a CPA that you trust and knows what they're doing when it comes to small business. It's good to have your attorney by your side, also a financial advisor, life insurance agent, those types of things. Make sure that you have good people. We have lots of people in our back pocket to recommend as CPAs and financial advisors. So this is a good slide to take a picture of. This is a question that we get asked a lot. We will share the recording of the webinar today so you can go back and refresh yourself on some of these things. Oh, go ahead.
Sorry, go ahead.
No,
I was just going to say, we talked pretty generally and high level about things. So when you get the email with the recording of this, or if you just go to our website, evansdavis.com, you can shoot Natalie and I an email if you have specific questions. And we can kind of answer more detailed questions that way, because while we were focused on business planning, we touched on a lot of estate planning topics in a short amount of time. And maybe you have some more questions on how that works with your business planning as well. So
yeah, if you all have any other questions, please send them. We have a little bit of extra time until we jump off at 1, so we'd be happy to answer. Or if you have some really personalized questions, feel free to email us, call us. We would be happy to answer your questions, set up meetings. We are meeting via Zoom, phone call, and in person. So we are happy to talk to you all. We got a question that asked, what's the general process of switching from LLC to a C Corp? So that is it's kind of a complex process to go backwards, but we can do it. And it may be just depending on how long your business has been in place, we'd work with your accountant to figure out how to transition, but it can be done. And that's probably more of a one-on-one conversation, but
depends on kind of the assets that are in the business, right. Tax considerations, things like that. So.
Yeah. Awesome. Well, I think that we will wrap up, but feel free to write down our emails. And we will be here to answer any questions. Thank you all so much for joining us, and we hope that you have a great rest of your Monday.
Yeah, definitely. Thanks, everybody.